Rentals up, especially hit very badly. What's the landlord doing if his place is now empty? Well, the tenant moved out, and there's no new tenant. He must now advertise his place. It will be standing empty until the end of the lockdown, because you can't show a property. You can't find new tenants. They can't move in.
Very tough at the moment. Shame.
And you could be a landlord of a portfolio of 30 properties you're renting. Can you imagine if there's a lot of movement? What about students at the moment who are giving up their places because very clearly students will not go back to university before July?
Yeah.
I mean, Francois Verulli, when we did our last webinar, in fact, told me that they've decided their students in Cape Town are not going back before end of July.
Yeah, 27th. My daughter's at Stellenbosch. They've said 27th of July.
And my daughter's at Potchefstroom, so she's also here at home until possibly July.
Yeah, they're doing the online. Thank God they can do that, eh?
Yeah.
I found it amazing how quickly all these teachers, even at schools, and that have put together online, everything online. I think they've done a great job.
Now, Wits University is going online as from Monday, next Monday.
Yeah. Yeah. No, it's good.
The sectional title, Managing Agents, obviously said will be a huge challenge of all the AGMs coming up.
Yeah, they
go on webinars, go on Zoom.
Yeah, Zoom meetings are going to be something to deal with, and some of them are actually just not having the AGMs. They're using a section in the Act which says that you can waive having your AGM as long as everybody agrees on the agenda.
Well, the Act is also saying that you can have meetings, but you can. It doesn't need to be physical meetings. It could be in any other way. So we're obviously referring to Zoom as an effort to have meetings. It's a bit of a challenge because what about your voting cards?
Yeah. But you know what, Louis, at the moment, there are like 3 or 4 people who are busy doing these digital portals for having meetings and AGMs and things. With voting, with everything. So voting opens in the morning, and you can go, you'll have the agenda and you'll have the whatever you're supposed to be voting on, like they do in New South Wales. So it opens in the morning, and then they can vote, and then the actual meeting takes place at like 6 p.m.
Yeah, unfortunately, the Act is making provision for that possibility. There are 2 requirements, obviously. One is that the people must be able to communicate with each other at the meeting.
Yes, and be identifiable.
And they must be identifiable. So there are the 2 requirements in the Act, it's in the regulations.
Yeah.
But then it's possible. So I can see AGMs becoming electronic. I can see trustee meetings becoming electronic. That will be a great help for managing agents.
Okay, guys, we just got
managing agents. The biggest problem with managing agents is their turnover of staff with their portfolio managers. Because at the end of the day, I mean, who wants to go to a meeting and sit there from 6 o'clock till 9 o'clock when you're a woman who's got children at home or whatever, if you're a portfolio manager, when you can have it from your lounge?
Yeah, I find that the big companies we're dealing with, portfolio managers are often sitting with 20 properties we're handling.
Yeah.
You can imagine with 20 properties, you've got 1 trustee meeting a month. You're out every night of the week.
That's it. That's it.
By the time you get back home one night, your family is not there anymore.
Guys, can we just try and increase this comment about the sound being a bit low? So can we just try and increase it to about 60% or 60 to 70% in terms of the settings? Marina?
Must we do that now?
Yeah.
So Greg, I'm actually going onto the group now.
Yes.
Guys, we're hearing the comments. We're just gonna change the sound.
Okay. Let me get into the group.
Is that better?
Yeah. Graham? Yeah. What are you on, 70%?
Now. Greg, must I go up?
Yeah.
Next.
What does my sound like?
Yours is better. Yeah, Joyce Spencer is saying it's better already. Graham, thanks, Joyce.
Greg, how's that?
What is yours now on?
I just had to switch something off.
About 70%.
Yeah. I think they're saying it's okay.
All right, Greg, I'm just accessing the.
Still a bit of echo.
What must I do?
I'm going to cut the echo out on my side.
Right, I've picked up the link. How's it sound, Greg?
Are you recording it again? Are you doing a video?
Yeah, we're live at the moment, Louis. I think whoever's not talking, if we can mute, it will help with the echo. Okay, so I'm going to mute myself. You'll see myself mute, and then you guys can mute yourself if you're not talking. And obviously unmute if you are talking.
Okay, we can do that. Greg, I just see on the Facebook Live presentation, all 4 pictures are not coming through. I don't know how it's looking on your side.
I see it all coming through. I see it coming through.
Can you see all 4 pictures?
Yeah. I think the sound.
So does that sound all right now? Greg?
Yeah. I think. Graham, what's your sound at? 70% or more?
I'm at about 70, Greg.
Okay, just pick yours up to a little bit more, 80.
Okay, how's that?
Okay, that's fine. Okay, let's go.
How's that sounding?
Right. Okay, that's fine. I think we're going to get clipping if we're going to go too high. Okay, you guys can start.
Greg, you muted yourself.
You guys can start. I think we can start the discussion.
Yeah, all good. Yeah, so morning to everybody that's watching this Facebook Live presentation. You should be able to pick up the feed quite easily. It should just be popping up on the feed if you're on the Property Practitioners group. So we've got some interesting topics to talk about today. I'm not quite sure as you're looking at the screen where everybody is as I'm looking at the screen. So my bottom right, and it's actually such a pleasure to have somebody much better looking than all of us for a change. And so Louis, I'm not talking about you, huh? So I'm talking about Marina Constance. As I look at the screen, she's in the bottom right-hand corner. So Marina, if you can just give us a wave in case people don't know where they're looking.
Hi.
Good. So Marina is a practicing attorney. She's a director of a firm called BBM Attorneys. I'm sure that most of you out there that are watching this particular live presentation would have, at the very least, read a lot of the stuff that Marina's written over the years. And so Marina is a sectional title and community schemes expert extraordinaire. She's also co-author of a best-selling book in South Africa called Demystifying Sectional Title, which she, which she wrote together with Karen Blaze, who now actually works in the Ombuds office. So Marina, unfortunately, I don't have my copy of the book to hold it up and to show everybody just what it looks like. I don't know if you've got a copy there. Have you got a copy to hand?
Not right with me, but I'll try and force one.
Okay. And joining us is Advocate Louis Talliard. So Advocate Talliard is in the bottom left-hand corner as I'm looking at the screen. So Louis, if you just give us a wave.
I'm here, yeah.
And of course, many of you will know Louis. So not only is Louis an advocate, but he's also a registered valuer, and he has been teaching property practitioners for probably the better part of 40 to 45 years, somewhere around about there. And it's always nice, Louis, that I can just lean on you and abuse you the way that I do to ask us to join us. But of course, the property practitioners that watch these presentations absolutely love the knowledge and the wisdom that you're able to impart. And then, of course, finally, those of you that don't know Greg Nathan, Greg, if you can just give us a wave.
Hi, morning, property practitioners. Hope you're having a good morning.
And thanks, Greg. And Greg is the person responsible for creating the Property Practitioners Group and allows us to run these Facebook Live presentations quite seamlessly because he operates all the technology behind the scenes. So what it is that we are going to be talking about today is we're going to be having a bit of a discussion around sectional title and also about the CSOS Act. We're just going to do a bit of an introduction. In a couple of weeks' time, we are more than likely going to have a much more detailed discussion around CSOS and the Ombud. So Marina and Lou are perfect guests to talk about this. And as an added bonus, we're going to have a discussion about what we believe the impact of the reduced interest rates are going to be on the property market for all property practitioners out there. So, Marina, if I could just start with you, and then just maybe take the view that the people watching us don't have detailed knowledge of these concepts. You know, we talk about sectional title, and there's often a lot of confusion. What's a section? What's a unit? So what do people buy? Are they buying a section? Are they buying a unit? What is it that they're actually purchasing?
Well, sectional title, you need to understand the terminology, and I think especially for estate agents who are selling in this industry, it's important from a sort of level of sophistication point of view, because there's so much more knowledge out there and so much more information out there for people. So you've got to understand the terminology. So if you're looking at a unit, if I'm buying a sectional title unit, it's actually made up of the section that you're purchasing, so the actual home, the square meterage that you're buying, together with what they call an undivided share in the common property. So an undivided share in the common property is simply that you have a share. It's not specifically designated, but you've got the use of an area of common property. So that would be, for example, like the lifts, the corridors, sometimes the gardens outside. It could even be a common property area, it could even be a balcony. It depends what it's designated as in the section plans, and obviously the Act will tell you. But the plans, if you look at it and you see CP, that means common property. So when you're buying your unit, it's your section and your common property areas.
So Marina, just sort of to try and simplify this a little bit, if I then understand you correctly. So the part where you live, that's going to be your section in essence.
Yes. Yeah. The part where you
yeah, so I'm saying, so the part where you live, that's going to be your section. And then the driveway areas and the gardens, and there might be a swimming pool and all of that type of thing. So that's going to be common property.
That's common property. But as with all things in law, there's always a little bit of complication, because you also get something called an exclusive use area. So your exclusive use area is common property, but it's been drawn up to be for different people's exclusive use area. So it can either be, let's take, for example, a garden. Like if I've got a little walled garden, everybody says that's actually my garden. Well, it might be common property, or it might be your registered exclusive use area, which means that it's in the deeds office, it's registered in the deeds office. You have we call it in the book, a first prize right to an exclusive use area. It's capable of being bonded, it's capable of being sold. So that's an exclusive use area. Or else you can get an exclusive use area created through the rules. Now the conduct rules or the management rules. So you've got to be a little bit careful if it's that carport, is it common property or is it exclusive use area? And I always say to estate agents, you need to understand what you're selling. So keep a file, keep your sectional plan and see what are they? Are those balconies common property? Are they exclusive use areas? Do you understand the difference?
Greg, if I can just interrupt for a moment, I'm seeing some comments about the sound. If we can just do a sound check on your side.
Yeah.
How are the sound levels?
I think Graham, you probably try and cut your sound on your side down to 70 maybe.
All right.
The echo's coming through. Even though it's a bit softer, I think we're gonna have to play off the level of sound versus the echo. I'd rather get less echo.
All right. So I've gone down to about 70 now.
Okay, Marina is fine. I think it's just coming from your side. Marina, you on?
And I see that, so most people now, it seems that the sound has improved.
Okay.
And Sakile Moremi actually asked us a question. So the question is that they weren't able to hear, so we're just going to repeat. So Marina, I'm just going to do a little bit of a summary there. So really what we're saying in general is that the area in which you live is part of your section, so it needs to be enclosed. It's going to have to be an enclosed area. But the interesting thing is that we've got things like gardens that we might have the use of, and we also might have things like a swimming pool in the complex that everybody can utilize. So how do we distinguish between these areas? And the point that Marina is making is that even the garden that we have the use of may very well be common property, but it's what we call an exclusive use area. And the exclusive use area means that as the owner of that particular section, so I'm entitled to the right of use of that particular area. So Louis, if that weren't the case and I didn't have exclusive use of those areas, would that mean that 25 of my best friend neighbors could then pop into my garden and have a braai on a Sunday? Obviously not at the moment with the lockdown regulations, but if it wasn't an exclusive use area, so where would that place me with regards to all of my other neighbors being able to use that area?
Graham, yes, if you don't have an exclusive use area, it's common property and can be used by everyone in the complex. That is the reason why we are creating exclusive use. You don't want someone to come and sit on your balcony, use a ladder and climb up to your balcony to come and have a braai. You want that privacy, especially if you put a splash pool in your little garden, obviously with permission from the body corporate. You don't want the whole complex to come and swim in your little splash pool. The big problem with exclusive use is that under the old 1971 Act, we could only do exclusive use under the rules. When the new 1986 Act came out in 1988, they've done away with exclusive use under rules, and they only created registered exclusive use as notarial deeds in the deeds office. That was much more expensive for developers, and we then found that for a 9-year period between 1988 and 1997, thousands of sectional title schemes went up, and developers didn't put any exclusive use in place. That's a huge problem in the industry today, because now you find only since 1997 they've amended the Act and they brought in the rule-created exclusive use again as an alternate to a registered one. And we now sit with thousands of sectional title schemes in South Africa without any exclusive use in place. Agents don't know that, and they sell these places, they put into the contracts that exclusive use are in fact in place, which is not the case. a buyer is buying the unit only to discover afterwards there's no exclusive use, to his detriment, because he's now not protected. And he may even claim reduction in purchase price from the seller because he sold him something he could not deliver. So there's a huge lot of places in South Africa where exclusive use is not in place, and we must now from time to time assist body corporates to put it in place. The cheap way, obviously, as Marina said, is the rule-created one.
So, Louis, obviously now, I mean, we're getting quite technical, the 1971 Act and the 1986 Act, and so we just want to try and obviously make this as simple as possible, because, you know, obviously the property practitioners out there wouldn't have detailed legal knowledge to be necessarily able to understand legally how these rights were created. So, Marina, if I can just come back to you, we are going to do a future Facebook Live presentation specifically on a checklist that property practitioners should be using when listing a sectional title unit, and obviously the type of information that they should draw out from the seller in order to be able to communicate to the buyer, because we know in terms of the current estate agent affairs board code of conduct that estate agents, as they're still called in the code of conduct, need to disclose all things that they are or should be aware of, and that could be material. So what Louis is talking about is obviously very much a material issue. So possibly maybe you can just give us a little tip or a little hint. How would property practitioners find out, number one, if the garden is in fact an exclusive use area? And where would they look? How would they get this information in order to be able to list the property correctly, that they don't end up with the type of problems that Louis is talking about? So just in simple terms, so how would we find out? Where would we look to get this information?
That's a great question, Graham, and I think it's an important one. So it's really very simple. If you do a deed search, or you get the attorneys to help you with your conveyancing to do a deed search on the property, you would be able to see, they would be able to tell you if they're exclusive use areas registered as carports and things like gardens. They're able to get that off the computer, off the system. So that would be one way of doing it. You can also get a plan. You can ask them to pick up a sectional title plan, all online, and maybe they can assist you to just read it, to go through it. It could be a service that they offer to show you exactly what is what, and of course also the rules. It's very important. And I always say to our estate agents, if ever I do seminars or give talks, make friends with the managing agent. Make friends with the managing agent. You sell properties in generally the same complexes if you've got sort of your territory, so you know the lay of the land. And it would be good to go and have a chat with the managing agent to find out what's going on with a specific complex at a specific time.
So Marina, then, if I understand you clearly, so this information should be identified on the title deed of the property. Is that correct?
It would be on the deed search, yeah. The deed search.
On the deed search. And so for a property practitioner out there that's working in an estate agency or a brokerage, they would have access to that by having an online system where they could do that deed search?
Yes, well, they should. A lot of the estate agents do have that. Alternatively, you need to just speak to the conveyancers who assist you.
All right. So I think really what we're saying is that for any property practitioner out there, if you are going to be working in a particular sectional title scheme, you need to know what rights are registered in that scheme before actually listing the property. And so your starting point would be to get something like the title deed from your seller that you're listing the property for. And also what you would need to do is get in contact with the managing agent, which is always a good idea because the managing agent is going to be a very useful source of information for you as a property practitioner. Correct?
Yes.
So Marina here, there's a question that's popped up, which I'm going to ask to both you and Louis. So this is from Senza Gakona Twabi. I have a veranda outside my front door. I've asked the question at the AGM if it's my exclusive use, and they said no. I'm assuming that this would be the managing agent. This has left me confused. Okay, so who does it belong to? And in fact, the last part of the question, does this mean that anybody can come and chill on my veranda? So what advice would we be able to give to Senza?
You want me to answer that?
Yes, go ahead, Marina, go ahead.
So there could be a couple of sort of permutations. The first one would be that it could be common property. It's probably unlikely if it's a veranda situation. It's more likely that it would be part of the section, would form part of his section. So you've got to look at that as well, because then if it forms part of the section, there are other consequences or implications that you need to look after it, and it forms part of your what we call participation quota. So it forms part of how much you have for voting rights, and for liability. You have to pay a higher level of a contribution towards your levies if you've got a bigger unit. So these are important things that he needs to find out and see. But you can do that through a deed search.
All right. So, anything you want to add there? So, what's the quickest way for Senza to actually find out about his veranda, because he's worried about all of his neighbours? I think after lockdown, going out to the bottle store, buying those cases of beer that they've been longing for, and having a post-lockdown party on his veranda.
Graham, the problem with exclusive use is that it's not only helping to look at your title deed, you must obviously also look at your rules, because a lot of exclusive use nowadays are rule created, not registered in the deeds office as a notarial deed. So you must also get an up-to-date copy of your conduct rules. Often, and I think in most cases, we go the conduct rule route to register exclusive use. Management rule route is too difficult to get unanimous vote and 80% quorum. So I think Marina will agree, whenever someone is approaching her to register rules for exclusive use, she will go the conduct route. So you must get an up-to-date set of the conduct rules, and that will tell you there's exclusive use under the rules. That is in most cases nowadays done because it's the cheaper route. So once you've established that there's exclusive use, then you know you can in fact use your veranda without any interference. If there's no rules in place or registered or under the rules, then obviously you're in a dangerous situation. In that case, I suggest that the owner must approach the body corporate or the trustees of a body corporate and ask them to consider the possibility of putting exclusive use in place for all the owners. And as I say, the cheap and quick way will be a special resolution to be approved by the ombudsman.
So you and Marina, then I think probably the advice that we would be giving to Senza is to maybe go back to the managing agent and ask for a definitive answer from the managing agent as to what that veranda is, also what type of a right is it registered as, and possibly then to actually get a deed search done in order to see what was actually legally registered as the right. So I think that
and the rules as well, as Lynn said, and the rules as well, Graham. But the one thing I just want to add, sorry, and I think it's important for estate agents to know, is that the trustees are actually obliged, if there are exclusive use areas registered or rule created, to add a contribution on over and above levies in respect of those exclusive use areas. So it might not just be a levy that the estate agent needs to know about, but also the contribution for the exclusive use areas. And those contributions, in most of the complexes, I know a little bit of a thumb suck, but I think they're there to defray the costs of maintenance, water, electricity. So it's not a market-related value on square meterage. So estate agents, just be aware that, you say what the levy is, but you must also double check what the exclusive use area contribution is.
So, Marina, again, I think just to make sure that we've taken quite a complex issue and we've made it as simple as possible for people listening to us. So, if the exclusive use areas are registered, will people find that on the title deed?
They'll find it on the deed search.
Okay. So, in other words, when you look at the title deed, you're not necessarily going to see the exclusive use registered on the title deed. What you will find on the title deed is the section.
Yes.
And what property practitioners also need to be aware of is that it's possible that the seller might in fact own 2 or 3 sections, because you could, for example, have a lock-up garage, which could be separate from the living area. And you might, for example, also have, let's say, the seller owns, they tell you that they own a storeroom. And it's very possible that actually the seller now owns 3 different sections. One is the living area, one is the double lock-up garage, and one might be the storeroom that they have access to. So what we're saying to people out there is that you need to do a deed search in order to see what the registered rights are. And then, Marina, when you talk about, and Louis also, you've spoken about rules, exclusive use areas rather being rule created. So where will people find that? Is that going to be in, people talk about house rules? Where are they going to be? Where can the property practitioner find those rules? Let's just clarify that, Marina, if I can just go back to you.
Yes, well, you would need to uplift a copy of the rules, which are now with the community scheme ombud service, and you'd need to page through those rules. And one of the points, wherever it is in those particular set of rules, will be exclusive use areas created through Rule 10(7). So those are the rules that you're looking at, and you'll see exactly in those rules. There'll be a schedule which will very easily point out exactly which section is linked to which exclusive use area. So it'll be section 4 is linked to exclusive use carport number 1, section 5, very easy. There's nothing really too difficult about it at all.
All right, so Marina, if we can just repeat that, because I know that most schemes will have, as I say, what they call house rules. So the house rules will tell you what tenants need to comply with. They'll tell you whether you can hang your washing on your patio. They'll explain to you whether or not you can service your vehicle on the common property. So will we find the exclusive use areas in those rules?
That's it. Yes, 100%. In those conduct rules, as Louis was saying, we do it mostly by conduct rules. There used to be a debate. It was a grey area because the law wasn't clear. It used to say that you could make exclusive use areas through these rules. So we didn't know if it was management or conduct rules. But with the new legislation, it's very clear. And it's much easier because you only need a 75% resolution through the conduct. You've got to have people agreeing to this creation of these exclusive use areas. All the owners have had to get together and pass a special resolution. You need to get a layout sketch plan, and all that gets popped into the conduct rules and then nicely registered and filed with the community scheme ombud.
Okay, so we've got some very nice questions relating to this as well. Louis, so Annie De Silva's asked a question here where she says, what happens if the plans of the scheme differ to the actual unit? So what does one then do?
Graham, she's often obviously referring to the plans differing from a section. Remember, the unit is your section plus your undivided share of a common property.
Yeah, so I think that's already quite an important thing that we need to distinguish. Yeah. Is that the unit is your section plus your undivided share in the common property. So now, the unit is not just the living area. The unit is the section plus the undivided share in the common property. So I think that's the first thing, is that we need to indicate that what Annie's more than likely talking about is the actual section. No. So now, Louis, she's got a set of plans, and the plans indicate what the section should be looking like. And it's now, in fact, different because the previous 3 owners have done a whole lot of renovations, and it's now a completely different thing.
Well, in that case, it means that there was now illegal addition to the section, and it was never changed on the plans in the deeds office. There's now a whole process to get it right. The owner will have to, uh, first of all, approach the owners at the AGM and the special business with a 30-day notice and apply for uh, consent to do the alteration. If the owners do not consent with a 75% special resolution, then you'll have to break down and return the unit or the section to the original condition. But if the owners are in agreement with a 75% resolution, you must then submit plans to the local authority for approval. Once it's approved by the local authority, the architect or land surveyor must come to the property and they must remeasure the units or the sections, and he must draw up an amended sectional title. The plan must be approved by the Surveyor General and then registered in the Deeds Office as an amended sectional title plan, and your PQs could be different. One last problem, if your PQs are becoming more than 10% bigger than your previous PQ, then there's another requirement in the Act that you must get consent from all the banks who's got bonds in the property. Fortunately for us, they've relaxed that point in the Act with an amendment in 2010 that you don't need to get the physical consent of the banks for an increase of more than 10%. You only need to send registered letters to the headquarters of the banks who hold bonds over the properties in the complex. It makes it a little bit easier, but it's a huge process. And a lot of people are making additions to their sections without following the whole process. Then it's illegal.
So, Lou, I think we must just go back a step because we introduced some new jargon here, which people might not necessarily understand what we're talking about. So you've just thrown in two letters there, PQ. So PQ stands for participation quota, and really the participation quota is utilized for a number of important things within sectional title. In simple terms, the participation quota would be calculated by taking the size of the floor area of your section and dividing by the floor area of all the sections put together. So you're then going to land up with a particular number. So that might be, let's say, maybe 2.3678. And that really is now your undivided share in the common property. So you own 2.3678% of the common property, and it also is used to calculate the size of your levy. So that's your contribution towards the common running expenses of the body corporate. And then also, as Louise indicated, so the important thing here is that if you are going to do an extension to a unit, because you are changing the floor area of the whole scheme, what's happening then is that you are also potentially affecting the size of your participation quota. So, Louis, I think it's obviously very important that property practitioners do actually have the plans so that they can see that things haven't changed over the years. Marina, Chris Phillips has actually asked a similar question as well. And what Chris is asking is that problems often arise when trustees have given consent to extend a unit, but building plans have not been changed and nothing's been amended. The sectional plans haven't been amended. The owner often thinks that he technically owns this extension as it still forms part of the common property. So I think you'd probably agree with Louis in that respect is that it's important for the estate agent or the property practitioner to make sure that they do actually have a copy of the floor plans of the whole development, of the whole sectional title or community scheme, in order to see whether in fact changes haven't been made. And I think that the tip here for property practitioners is that you might find that there's a change in building style, so something looks different, and it's very clear to see that there has been an addition or there has been an add-on, And sometimes you find in these various properties is that it just looks odd. It looks like something's been stuck on because it might be an enclosure, it might be an extra area that's been built on, and you can see that it's been built at a separate stage, which should then obviously raise some sort of suspicion in the property practitioner's mind. So, Marina, anything you want to add to what Louis said?
No, I think that's it, and I think that the property practitioners need to be really mindful when they're taking people around, and not to be you say, look, yes, you'll be able to extend here, you'll be able to build on your a baby's room maybe if the lady falls pregnant, or if you want to work from home or you want to do something, you can always extend it. Those are really, really dangerous things to be saying because you don't know, firstly, if there's enough bulk in the scheme, floor area ratio. You don't know that you're going to get a special resolution. The chap who asked the question before said the trustees said I could extend this. The trustees have no right to say anything about extensions. It's about the body corporate. The owners, by 75%, have to decide whether or not you are entitled to extend that. And lately, I must say, I've been having a lot of Zoom meetings with owners and people on the ground. And so often they say to me, yeah, but the chairman said I could do that. The chairman is not God in a complex, and neither are the trustees. And ultimately, you need to understand that you need that buy-in from owners to give decisions like that.
Yeah, so I think that, Marina, what we need to distinguish here between two possible things. So let's say, for example, somebody wants to take out a set of maybe old windows and they want to put in sliding windows. So that could then very well be just a simple written application to the trustees in order to ask whether or not one can do that. And of course, the scheme will have certain rules in terms of what the windows may have to look like and the type of material that needs to be utilized. That's very different from doing an actual extension to your particular section, where, as Louise indicated, you may very well have to call a special general meeting and you need to get that 75% vote in favor of what it is that you're requesting to do.
Yes, for sure. And the big trend at the moment is where you've got an older complex, like I chatted to a guy at Hartbeespoort and one of the big developments there, and you've got all this young blood coming into the scheme and wanting to change all the thatch and the wood and all of that. That's got to be something really dealt with in a considered manner by trustees who need to become flexible and need to put it to owners that all this modernization can be done properly and very happily in a streamlined manner, but it's got to be kind of way.
So, Marina, Violetta's asked a couple of questions. So she says, so rules can change. Can exclusive use under rules also change? In other words, if you've got exclusive use areas that have been created by means of rules, can they be changed? And the most important question that she's asking is, for property practitioners, how do property practitioners actually protect themselves when selling? And I think we've partially answered that question already in terms of property practitioners making sure that they have a copy of the plans of the scheme. They need to make sure that they've got a copy of the rules. They need to make sure that they've got title deeds of the properties that they're selling. They need to make sure that they've done a deed search. So, it's not just a simple thing of listing a sectional title property. You really need to know what it is that you are selling. So if we just go back to the first part of her question. So if you've got rules that have been created, if we've got exclusive use areas that have been created under rules, or we've got rules themselves that you can have, one dog and now somebody's got 3 dogs. So can rules change? Is it possible that rules can change? And how do property practitioners protect themselves?
Yes, look, rules can change, definitely. And that's why when we talk about exclusive use areas, when I say a first prize exclusive use area is the registered one in the deeds office that it's a notarial deed of cession, and that is yours. That's a real right. It can't change. But if they're under the rules the rules, if they're under the conduct rules can change. So yes, if 75% of owners decide to shift around carports or whatever gardens, then that can change. And rules are changing all the time. In fact, I'm encouraging trustees all the time to say, are your rules tailor-made for your... Cannot believe the number, Graham, of archaic rules, and I think Louis must also know this, archaic rules that are still in schemes, which really don't apply to a scheme at all. So it's important to get those rules amended. And then, of course, you need a compliance certificate now from the community scheme ombud, because the things that people were putting into rules also were really a bit scary. So you've got them being picked now as well.
So, I mean, Marina, you and I have had a chat, for example, previously about Airbnb.
Yeah.
And we're going to say in a future Facebook Live presentation, we're actually going to talk specifically about Airbnb, because this is of course causing a lot of problems in a scheme where people are, for example, buying units in those schemes in order to be able to let them out for Airbnb purposes, and it's obviously causing problems because neighbors are not happy with the transient nature of the people moving in and out of the building. So really what you're saying is that you've got schemes that are maybe 35 years old that are still sitting with rules that were suitable from 35 years ago, and they need to be updated. And Marina, obviously, of course, if trustees are not sure about how to go about doing this, they would be able to approach specialists like yourself, like Louis, in order to be able to assist them to do these rule changes. And that's probably the suggested way to go, instead of trying to do this as a DIY job and then it becomes a complete mess.
Well, yeah, I would agree with that. And I think it's important because people like ourselves have experience in the industry and know what the ombud would allow and what they wouldn't allow, what they'd kick out. So that's, at least you have the expertise.
Yeah. Louis, so Tracy Foss has asked a very interesting question here. She says, would somebody be able to install a splash pool in their garden if the garden is an exclusive use area? Can you just go ahead and put in a little splash pool for yourself?
No, you can't just go ahead and do it. You must obviously apply to the trustees for permission. You don't need permission from the owners if it's an exclusive use, but you still need permission from it to put a splash pool in.
So Louis, would that be a simple written application asking the trustees, I want to put a splash pool in my garden, it is an exclusive use area, can I proceed?
Yeah, you must obviously submit plans for the splash pool, and in certain local authorities, they may even insist that you must have plans approved at the local authority. It differs from local authority to local authority, but you must have permission.
There's obviously, sorry Louis, sorry to interrupt you there. There's obviously a practical issue here as well. You've got things like the noise of the pool motor. You've also got issues like when the pool is backwashed, where does the water run out to? So these are all things that the trustees themselves would have to consider, not so?
Yes, and also the amount of water you're going to use. They may insist on a water meter for the water you're going to use in the splash pool. And there could be rules coming in how to control your behavior in the splash pool. But you're not doing it up to 2 o'clock at night. It depends. Who are your neighbors? I always say to agents, there are mainly two types of people who are buying into sectional title. The nearly weds and the newly deads. So these are two greatly different type of people, and they may not get on so well. And the splash pool could become a huge problem if there are neighbors next door who are not enjoying what you're doing.
Louis, just while we're talking about gardens, a follow-up question that Tracy Foss has asked. She says, can you apply to have your garden incorporated into your section if it is not registered as an exclusive use area?
My short answer to that is you can't. Your garden is not a part of your section. Sections are areas which must be measurable by the land surveyor, because he must measure from the middle of a wall to the middle of a wall, because only the inside of walls are belonging to the owner's section. So a garden, unless there are specific boundary walls you can measure, is normally not included. I find that developers often are excluding even balconies from the section because it affects the amount of square meters they can build in a complex.
Mm.
So if you look at the plans of a big complex, you find that even balconies will show a CP because the developer can now put in 100 units instead of 90 units
Mm.
because your floor area ratio is affecting what he can build on that premises.
Mm.
So it will help if your balcony, for instance, is a part of your section, because if you then want to enclose your balcony, you don't need to apply for an extension under Section 24. You only need to apply for permission from the trustees as far as the outside look of your windows on the balcony will be. And then you must only apply with, I think it's Rule 29 or Rule 30, dealing with not affecting the harmonious appearance of a building, not reducing the value of properties next door. And it's not application or a permission you must get from owners.
So in other words, the general rule is that anything that's enclosed, so effectively we would be talking about the living area, that would be part of your section. And the question that Tracy's asked here is that to try and get a garden incorporated into your section would be now today really pretty much impossible to do. But Marina, it might very well be possible to have it incorporated as a rule change as an exclusive use area. What about that? Would that be possible to do? You need to put your sound on, Marina.
Yes, I think if it's yeah, it would be. You would be able to. Gardens are a great example of what would be registered as exclusive use areas to the rules.
Mm. And then Marina, so Meryl Heffer's actually asked a question as well. She says, what about a carport? Does that affect your participation quota?
No, carport is not registered as a section. So when you hear the word participation quota, you need to just think about your section divided by square meterage of everybody else's section. It's got nothing to do with anything else. So no, yeah, it's not. It wouldn't be. It wouldn't be as part of the section. It's usually either CP, common property, or exclusive use area.
Mm. So Marina, so here's actually also the thing that can be a little bit confusing, because you've now got almost the clash of town planning requirements and the requirements of all of the sectional titles legislation. So where you have a carport, because a carport is permanently covering the land, what that's going to do is that's going to affect the coverage requirement of that scheme. So any particular piece of land in any local authority, in any municipal area, there's only a certain percentage of the land that you can cover with a structure or structures. So what you might very well have is carport that impacts on your coverage requirement, how much land can you actually cover, but it has no impact on the participation quota. And Marina, I think here's also another important issue is that if the members of the scheme have a special general meeting because they all want to put up carports because their cars are standing outside in the sun, it's very important that they actually call in an architect and a land surveyor to actually check whether or not they're going to be in contravention of the town planning requirements, that they're going to end up covering too much of the land. And also, of course, they would need to then...
Exactly.
They would have to do a submission of plans.
Yes. It's a two-prong. It's always a two-prong approach that the trustees have got to look at. But very often you'll get an owner, for example, who will put up a structure or do what he wants to do, and he'll come back and say, yes, but I got municipal approval for that. But that's not good enough. because you don't need only the municipal approval, you need the body corporate approval as well. And I think that's often forgotten.
Yes. So, Marina, there also been a couple of questions about trustees. And I think that this is obviously a very thorny issue because, you know, you have, I know when I teach property practitioners sectional title issues, you know, I normally characterize the various trustees. And the characters that for me come up time and time again. You know, Louis spoke about the newlyweds and the nearly deads in sectional title. So you often have your older people in sectional title who may have been in the scheme for many years, and they like to police the scheme. You know, that person I characterize as Mr. Plod or Mrs. Plod. So that's the person that's going to make sure that you leave your rubbish outside when you're supposed to, that you don't in fact swim in the swimming pool outside of times when you're supposed to. So that really is the policing person of the scheme. And obviously you also have in a lot of schemes trustees that maybe as a result of, you know, that they're very busy at work or they've got other things that distract their attention, so they're not always that interested in the scheme. So you often have those type of characters who make up your trustee body. So, you know, what role and responsibility do the trustees have here? It's all very well to put your hand up and say, I want to be a trustee, but what's the role? Just if we can just try and summarize it, what is the role and responsibility of the trustees?
Well, the trustees are now playing an increasingly important role in the managing of a sectional scheme, particularly since the latest legislation. And I mean, trustees have a fiduciary duty. Sectional Titles Act stole that word from the Companies Act, although the Companies Act doesn't actually apply in sectional title. So fiduciary duty, what is that? That's a duty of care and skill and diligence in acting towards the body corporate and the owners and acting in their best interests. You've also got the Community Scheme Ombud Service Act, which has now promoted trustees and directors in homeowners associations to be called scheme. And there's a really a very high level of onus on trustees and directors to understand the law, to be educated. There's a regulation which talks about in the Community Scheme Ombud Service Act, which talks about trustees having to educate themselves, having to find out the law, having to give written excuses if they're not going to attend meetings. So there's this increased responsibility, and not only on educating themselves, but also that fiduciary duty. If they breach that fiduciary duty in any way, they can be held personally liable for any acts or omissions in the sectional title complex that they deal with. Whereas before, they could only be held personally liable, if they were grossly negligent. That's a tough test to pass, or if they were convicted of something like fraud. So it always stuns me, Graham, and I don't know if you'll agree, Louis, that people at meetings, they'll sort of, even at the meeting, they'll be asking their fellow people at the meeting, but what do you do? What do you do as a trustee? What is it about? You know, listen, after 6 months, they know what it's about, for sure.
So, Louis, Chris Phillips has asked a question, or he's actually made a statement. He says, I think that trustees should be held accountable if they give their consent to allow things like extensions where these haven't been approved by a general meeting of the members of the body corporate. So can the trustees actually be held responsible for providing such consent without having a vote at a general meeting of the members of the body corporate?
Yes, absolutely. If a trustee is acting without authority, and if he's acting as we access with mala fide, that's now bad faith, then he can be held personally responsible. I find a lot of trustees are accepting the nomination as trustees and become trustees who have absolute no knowledge of the Sectional Titles Act. Let's say a trustee is giving you permission to build a splash pool or a lapa in your little garden in front of your premises, and it was not passed by all the trustees, uh, that's gross negligence, and he could be liable. He could be held personally liable for that.
So in other words, what we're saying is it's not just a simple issue of saying, well, I'll be a trustee. You really should be getting yourself up to speed with what all the legislation requires. As Marian has indicated, we now talk about scheme executives. So it's not really just a simple thing as saying, well, look, I'm happy to attend a meeting, every 8 weeks on a Thursday night, and we can talk about, the barking dogs in the complex. We're coming towards the end of our hour, so I want to now start bringing our session to a close. And Marina and Louis were really following on from this question that I've posed to you about the role and responsibility of trustees in the current environment with the lockdown regulations. So where do trustees now sit with all of this with regard to enforcing the lockdown regulations? Marina, I know that you've got a particular point of view, and I know you and I have discussed this in some detail as well. And there's obviously been some stuff that's been written in the press with other practitioners with opposing views. So, my understanding is that in terms of the current lockdown regulations, so the question really that arises is the common property part of your place of residence? Can you actually use the common property for that particular purpose? And so I'm just going to pose that question to you, because there are obviously two schools of thought here as to whether it is part of your residence or it isn't part of your residence. And following on from that, so if we take the view that in fact the common area is part of your residence, and the trustees have told everybody that they cannot walk in the complex or they cannot walk their dog in the complex, what rights do the trustees have to, in essence, enforce these rules? Because of course this is where all the Mr. and Mrs. Plods now want to enforce their power as trustees.
Yes. Such a big question at the moment. It's just on everybody's lips, and I'm getting phone calls. I'm getting inundated by people saying to me, yeah, there are these snitches in the complex, and they're all telling on everybody else. And I had a lady yesterday from Cape Town who is so upset that she's not in, can't go and commune with the mountain, she said to me. She actually went outside and danced on the common property lawn, and she said, if the police arrest me, it's tough luck. Anyway, so there are two schools of thought. There's a narrow view which looks at the regulation and says you're not allowed to leave the confines of your residence, and your residence, they say, is your section. Like any other home, it's where you live. It's got nothing to do with common property. Yes. And the Community Scheme Ombud service has actually taken that to heart, and they really encourage the support of that view. And you'll look at the directives on the Community Scheme Ombud website, which says that you're not allowed to jog or walk on common property, and common property amenities should actually be locked. So that's that school of thought, and I tend to get towards that school of thought, I must say. Then there's the other school of thought which says, well, actually, as you said, the residence is not your section. It's also part of your undivided share of the common property. And in that case, you look at Section 3(1)(t) of the Sectional Title Schemes Management Act, which says the trustees actually have the right or the duty to control and administer common property for the best interests of the body corporate. Actually, it's a function of the body corporate, but then that's delegated to the trustees who have to look at that. So then in that case, the trustees decide by majority vote how trustworthy the people in their complex are, and also based on how many units there are and the layout of the scheme. If people can walk, if people can't walk, if they can jog. I know that some trustees have laid out rules which give a schedule for people, right? The unit number 1, you're allowed out this time, out that time. which I think is also a bit odd. And then you've got chairmen who want to be phoned or SMS'd every time somebody walks on common property, so he can regulate how many people are on common property. So that's the narrow view, and then it's the wider view. And in my experience, my managing agent clients are saying to me, most of the complexes have taken the CSOS view of just saying you're not allowed out. Now, that's a tough stance to take, particularly in view of the fact that these lockdowns might continue and continue. They might have to move more towards the wider view. We've asked the Community Scheme Ombudsman to redraft that regulation and to look at giving us some real clarity on it. But to date, we haven't heard anything.
And so what the request that's been made in terms of redrafting that particular regulation, is that to allow people to use the common property or not to use the common property?
Well, that would depend on what the intention of the legislation was in the first place. And my view of that would probably be to lock down completely.
So in other words, people will not be allowed to use the common property because as you've indicated, there are obviously two very divergent schools of thought here. And that, the common area does form part of your place of residence.
Yeah.
So, as I've indicated, we will have follow-up sessions with regards to these discussions around sectional title. And I think we'll talk more about the trustees in future. Lou, I want to really finish off with this. And I think that this is now the multi-million-dollar question that's on everybody's lips and minds. We've seen, really, we had an absolute surprise decrease in the repo rate this week. I think for once the governor of the Reserve Bank really took us completely by surprise because he's by nature fairly conservative in his outlook. And I think a lot of people have thought that interest rates have remained unreasonably at high levels, and now we're getting what we've asked for, these lower interest rates. But of course, we've got a property market that's in lockdown. So what do you think the impact of this decrease in rates is going to be on the property market?
Graham, I think for the sectional title market, it will be a very good thing because I can see a downscaling of people in property. And that means a lot of people will move from full title to sectional title. They will move to cheaper properties because of cash flow problems, even after this virus thing is over. So the lower rates at the banks will mean that a lot of people will qualify to buy. And then at the bottom end of the market for properties under $1 million, I think it will be a huge stimulation. That means there'll be a big demand for sectional title. And a lot of tenants will realize that the rental they pay is now higher than their bond payment they would be paying buying the same unit. So I can see a lot of tenants who do qualify will become buyers, and it will be a boom for sectional title at the bottom end of the market. If I'm an agent, I will possibly change my product I'm selling, and I'm changing my area more towards the lower end of the market, and especially to sectional title after this whole lockdown thing is over. There could be a shortage of sectional titles in the market.
Yeah, Marina, I agree with what Louis is saying. I don't know what your thoughts are there.
Yes, I fully agree. And I think the message has gone out to market that it is the time to buy now. And yeah, I think maybe I should change and become a sectional title estate agent.
So Marina, just one last question that I want to pose to you again from Senza. And what he's asked is, can I hire out or rent out my parking bay, regardless whether it is an exclusive use area or part of the common property?
Well, certainly, if it's part of the common property, you're not entitled to do that. But if it's part of your the body corporate would be entitled to do that, but not you yourself. If it's your registered exclusive use area, then it would be different. And yes, you would be able to rent it out, but certainly not common property.
Okay, so it's quite a simple rule. I mean, if it's yours, however it's yours, you can rent it out. If it's not yours, so you might have a lot of schemes just have lots of open parking, and what's happened is that in a very informal manner, the trustees also have gone along and said that you can park here, you can park here, you can park here, which of course is also not the correct way to do it.
Mm.
But in such an instance, you can't go and rent out that parking that's theoretically yours because it's been pointed out to you
Correct.
as being yours.
Yeah.
So I think that we've obviously just really scratched the surface of such a massive topic. Um, you've obviously got a really majorly important part of our real estate environment and our property law. I know that today there's a very, very high percentage of building plans that are passed, obviously when the municipalities are operating, of building plans that are passed that are for sectional title, either residential or non-residential. I mean, we haven't even touched on non-residential and the amount of non-residential sectional title schemes that are out there. So, you have property specialists like Marina, who has built her whole career on community schemes and all the legal issues around community schemes. You also legal professionals like Louis and I do a lot of work together. There are a number of training programs that we run up to 5 or 6 days just on these community schemes. So it's really such a massive area of our law. And Marina and Louis, I see that Chris has also posed a suggestion here, and he said, may I suggest you have a session on the importance of trustees and managing agents understanding the law relating to community schemes and their practical implication. So, our hour that we've had together, and in fact, we've been now about an hour and 4 minutes, so we run a little bit over time, really has indicated that, in fact, the more we know, the more we actually don't know. It's such a vast area of our property law and our real estate environment. I want to thank both of you for your time on yet another Sunday this month that we're having. So, Marina, thank you very much for giving up your time and obviously all the preparation that we've had to do to create this particular talk. And Louis as well, also to you, thanks once again for your time. Obviously, the viewers that are watching us don't know the amount of effort that goes into putting these Facebook Live presentations together. And in that respect, we really need to thank Greg for running all the technology and making sure that this whole thing doesn't fall over and collapse. We know sometimes there are a few problems and sometimes the sound doesn't come through so wonderfully. But if you just think about how marvelous this technology is, that we're all located in different parts of the country and we're able to bring this type of a conversation together for people to benefit through this very difficult time that we are going to go through. And I think just really a couple of things just to finish off. We obviously await to see what's going to happen with institutions like the Deeds Office and whether or not they're going to be declared an essential service. Obviously, lots of property practitioners out there waiting to see what's going to happen in that regard. And of course, what's going to happen as far as the banks are concerned, insofar as re-looking at transfers that have been lodged, which haven't yet been finalised, and applications that have been made, and whether or not the banks are going to reassess those applications. So I am in fact working on really a very powerful Facebook Live presentation dealing with this. We'll give you more information as it comes to hand, and we will publicize that as soon as we have the information to hand. Should you wish to pose any questions based upon what it is that we've discussed today, you're more than welcome to go on to my website and go and have a look at our contact details, or you can email me. It's Graham, that's spelled Graeme at cpmd.co.za. And if you wish to get hold of Marina or Louis, you also are more than welcome to contact me, and I'll pass on your inquiries directly to them, and they can then be in touch with you. So once again, thanks everybody for your assistance. And I look forward to having an ongoing discussion with you with regards to sectional title. I think we had a great session today, and it was really, really wonderful to touch base and catch up with all of you around this very, very important topic in our real estate environment. Thanks, Marina.
Thanks,
Thank you
guys.
so much. Thank you,
Thanks,
everybody.
Louis. Thanks, Greg.
Thanks, Graham.